Okay, Vedant, can start.
So, good evening to one and all present here, and good evening to all our viewers. Good evening, sir. I welcome in today's session.
Good evening.
So, today we are having a discussion on the effect of civil defaulters, banks, and the role of courts. So, talking about Jus Corpus. So, Jus Corpus is a body of legal professionals who have came together to incorporate an interdisciplinary journal. Jus Corpus Law Journal is an edtech platform set up in either year 2020, having 600 plus clicks per month on an average basis. Jus Corpus Law Journal is a quarterly, double-blind, peer-reviewed e-journal that is open to students, academicians, scholars, and professionals in the law profession, and the allied fields to publish and read the content, which is published in the form of articles, blogs, case comments, and research articles. Just Corpus has published 600 plus manuscripts from 7 different countries, and it was also featured in top 100 legal blogs in India by FeedSpot. Just Corpus is the highest indexed law journal in India, having major indexing at Heen Online, Manupatra, and JK. So, talking about our eminent guest speaker of the day, Advocate Anurag Chaturvedi sir is an advocate of High Court of Calcutta and other High Courts of Kolkata. He was also the former member judge of District Consumer Dispute Resolution Redressal Forum and also served as the acting president. He has been practicing advocate since June 1991 before the High Court of Calcutta and other courts of Kolkata and the nearby districts. He is an entrepreneur turned advocate. He started by founding an extremely lucrative SSI unit at a very young age of 21, completely on his own after completing law, and he slowly transited into the legal practice. He had also founded an English medium CBSE affiliated school by the name Panchil Academy at Durg, Chhattisgarh, and had served as a founding secretary for some time. His educational qualifications are BSc, LLB, EDP trained honors, DIP ASM, CCAB, and specialized manager tech training course in export management. In the year 2001, while his wife Anjali Chaturvedi was the member judge of the District Consumer Redressal Forum, also served as the acting president of Kolkata Unit 2. He had been appointed as the member judge of the District Consumer Dispute Resolution Forum in the district of Howrah and had also served as the acting president. Later on, he got transferred to Bardhhaman Forum, and after serving as the member judge, he returned to bar and continues to represent independent client, nationalized banks in the various matters before the court of Kolkata and nearby districts. And he has the analytical approach for various laws and acts and enacted to tries to find out their bad impact on the society, which are normally ignored even by the legislator. So I again welcome in today's session, sir. Thank you for joining.
Before I begin, let me correct one thing. Mr. Vedant, I am Chaturvedi, not Tiwari. I was told that I am Anurag Chaturvedi. You were said that I am Anurag Tiwari. So I want to correct this part. Are you able to hear me?
Yes, sir. Sorry,
yes.
There was my manuscript.
Never mind. So let me believe that. Let me say my hi to all the young participants. Hello to all my fellow beings, and my respects to maybe elderly people may also be there listening to me. As Mr. Vedant has said, that today we'll be talking about CIBIL, defaulters, uh, banks, and the role of the courts also. So what is beginning with the CIBIL part? I'm coming. Now, what this CIBIL is, everyone talks about CIBIL. When you go to a bank, they say we want to see your CIBIL. When you go for for purchasing any item on hire, they say we want to have your CIBIL score through the Matlaki bank, and they ask for your PAN card to verify the CIBIL also. Now, actually, the CIBIL is nothing, but it is a Credit Information Bureau India Limited, which was formed in 2005 under the license from the RBI and under the provisions of the Credit Information Companies Regulation Act 2005. Prior to that, we had TransUnion Intermediate Holdings Incorporated, which had the main head office in Chicago, and it had regional headquarters in most of the important countries in their important cities. As in India, we had the regional headquarters of TransUnion in Mumbai. what was the idea of starting this? They used to follow the uh, loan disbursed and the repayment processes, repayment history, repayment status, and on the basis of the timely repayments, they started giving credit marks. And from that, the CIBIL marks used to go up. And when you defaulted, then they used to give it the, negative marking, and the CIBIL score used to fall. So when you have a negative, you have a lower CIBIL score, you are not eligible for loan. When you are having a higher CIBIL score, you are eligible for higher loan. So on the basis of this, the things started working. That was the time when we had foreign banks coming into the country, and they, as a matter of fact, brought this concept to our country, which was accepted by the Reserve Bank of India. So initially, everything appeared to be very fine, very comfortable. Oh, one will not have to go anywhere. If your score is okay, then you will get the loan. Let me cite an example. As we go for taking passport for Australia or for Canada, they have a score system. If you are of this age category, you get so many marks. If you are educated up to this level, you get this marks. And then now you are, after getting those credit marks, you get the visa for entering into those countries and settling there. So everyone thought this is very fine. But no, as a matter of fact, these European countries had something very different behind in their mind. They started this concept, and now it is being practiced everywhere in the world, in all the developing countries, which is nothing but the spying on the economic activities of the country and the economic status of the people living there and their banking transactions. They say that they are maintaining the secrecy. As a matter of fact, this secrecy is not there, because the reports, the CIBIL reports, are shared online with all the NBFCs and the banks. They don't mention the name of the banks with whom you are dealing with, but they mention the amount of money you have taken, the repayment history, and much more. So as long as you are sharing this is matlab ki in violation of your privacy of your accounts. Now, what is the bad impact of this? Maybe if you, for some reason, now initially means this part I told you about the CIBIL, what was the idea behind, and how they matlab ki wanted to work in our country, and in the other countries also they are working. So here comes the lapse on part of our government to have allowed it initially, because by introducing such marking system, those lenders, those who wanted to lend money to some people, those who had defaulted for one reason or the other, was stopped, and they were not getting the money. Now, this may appear ki also, when someone has defaulted, he is not getting money, so there is nothing wrong in it. One should not be given money, but no. Now, after talking of this about this, Sibyl, so now what happens when you go and obtain a loan or a credit card, or you go for the retail loan, you go for a car loan, whatever it is, maybe that you are a borrower and they are the lenders. So if for then the banks normally say, he come with some security or give a guarantor. So you come with a guarantor. When a guarantor is given, his details are also incorporated. Now, for some reason, you default in making payments to the bank. Your guarantor also comes in the red list. Now, when your guarantor goes for a loan for himself, he is not given. He is asked, unless until you get that loan cleared, will not give you, will not extend any credit facility to you. So these things are happening. I know one gentleman. He stood as a guarantee for one of his friends who purchased a commercial vehicle. Now, after 7 years period, when this gentleman who had appeared as a guarantor went to the bank, went to this market for buying a high price mobile, and on hire purchase, they asked him, give me your PAN card number. He gave that number. Bole, sorry, we will not give you the loan. Bole, why? Because you had stood as a guarantee. Now because that person has defaulted, now you are also considered as a defaulter, so now we'll not give you the credit facility to buy a mobile. Maybe that was some price to some 60-70,000 rupees, that was a thing like. So these are the impacts, how they link the entire society. Now initially when they come for giving extending loans, they are very liberal in giving. They give you credit cards, they give you so many EMI provisions on the credit cards, and the person goes for it, and he keeps on taking, and the rate of interest which is charged, if it is well calculated, then it will be found the rate of interest goes above 36 to 38, 40, it goes even up to the 40% per annum rate. These are the मतलब कि things मतलब कि which मतलब affect the credibility of the person in the long run. Now, if we talk about the CIBIL, then we'll say कि how it affected the our society. Then we will have to take the example of recession of the 2008. In 2008, during 2008-2010 period, the recession was there, and many people, those who had taken personal loans or availed credit card facilities or had business loans, they they failed miserably and they could not pay. The banks came forward to them. They said ki, okay, we will we want to settle our account with you, you come forward. Those people, when they are individual borrowers, you all will appreciate that these individual borrowers, they never want to go into any fight with others. They always think of their personal respect. They said, okay, we will come and settle the accounts with you. When they settled the accounts with them, the bank, they have a system of putting remarks in the CIBIL history, whether it is settled, whether it was written off, what was whether a court case was there, etc., etc. So at the time of settling the amount, they said ki now your CIBIL will not be affected. The borrowers, they somehow they managed and paid the settled amount. Now how this, what was this settled amount? Now I'll tell you this. We will have to think on all these aspects together, because unless we discuss this part, basically the CIBIL part, we will not be able to appreciate the role of the court, role of the effect on the defaulters, and the banking practices. So how the bank thinks of settlement, and what is the principle like. So when you take any loan, you are repaying in EMIs in general or the monthly. So the bank calculates ki what was the principal amount extended to you. How was I'm talking this in respect of a, say, personal loan which you have taken, on which you are making monthly EMIs repayments. Okay, now loan period is say for 5 years, and you are continuing for say 3 years or 4 years have already passed. Now only 1 year is left. So, but you have now landed into a situation where you're not able to make any further payments. The bank comes to you for settlement. They say, then when they come for settlement, what they say, they say, okay, we'll take only the principal amount from you and we will close the account. The personal things, borrower considers, oh fine, this problem will be over. Let me try hard, and he tries hard for. They, what the banks do, and how they calculate, whatever the EMIs you have paid, they take the total of it, and they constitute, and they reduce that amount from the principal amount which you have matlaki taken, and the whatever the remaining principal is there, that they bring forward, and they ask you to pay that either one time in one shot or in several installments. Normally people prefer installments, 3 months or 6 months, or maybe 1 year, or maybe they go for the one time payment, and they make the payment and get the account is closed and no objection certificate is also given. One feels very happy. Okay, but the thing becomes ki they have the access to put in the CIBIL history the remarks, whether settled or or written off, or court cases doing whatever it is. But all these remarks are having adverse effect unless until you pay their full amount which you had agreed to pay to them. So now this settlement is matlab ki, the history is, as the banks say, he will be in your favor, ki you have settled, now your CIBIL will be okay. But no, on the other side, it has affected them, and they don't get any loan any further in the future. Neither, and the most surprising thing is this, ki if one member in the family fails to repay the actual amount which was borrowed along with the full interest and the bank charges, no one else in the family is given any credit facility from the bank. And they have such an arrangement that not only that bank, no other bank shall extend. Now this problem is such, so this is nothing but a very vicious thing going uh, behind our scenes, where they say ki you we have taken money, you beg, borrow or steal, you have to give me. This is the phrase, beg, borrow or steal, is the phrase which was used in some courts also. I will not cite those courts. They said whether you beg, borrow, steal, but you will have to pay. We don't know, since we have taken the money. So now the question comes, when we talk, when we matlab ki talk to courts about the banks, and we say ki we are not able to pay, we should be we should be given some relief. The only word which comes back in respect of banks is ki bank is working with the public money, and so no relief can be given to you. It is public's money which we want to get repaid to them. So now here from this CIBIL, I am entering into the chapter of the banks. Now just think of, is there any enterprise under the sun which is not working with the public money? When we avail air ticket, the public money is there. When we avail railway services, the public money is there. When we go and purchase anything, public money is there. When we are going to the banks, public money is there. Now it is, the money is nothing but the stock of the banks. Had it been the scene that banks were owned by the government and their expenses were paid out of the taxes which were paid to the government by the public, then this concept of that banks are run on the public's money and the public money should be given back to them would have been held high. But no, this is not the fact. When you open the websites of the banks and go behind and see what they are about them, you open that part, you will find there are directors having 50%, 40%, 30%, 60% shares, and they have invested their money. So banks are nothing today but the business enterprises, because for each and everything you ask for them, they charge you money, the service charge. Even for a signature verification, if I am not wrong, they charge up to 200 to 300 rupees for one signature verification, which long back was given free of cost. We used to go and get ourselves introduced to someone, and we used to say, please attest our signature. The bank manager used to put his seal and attest yes, signature verified with our records. But for today, if you go to a bank, they charge fees for it. And not only the fees, now you will say, what, my this logic is not good. Well, if any service which is taxable is not with the public's money. Now, for every service which you are taking from the bank, you are paying service tax to them. The service tax concept which came from the Consumer Act. They initially introduced the service concept in the minds of the people, then the service charge, and then the government slowly and gradually came and introduced the service tax. So now banks are taking service tax. Whatever transactions we are doing today, we are paying 0.03% tax on all our transactions. That is why when we withdraw money from the ATM, there also that 0.03% charge, service charge is taken, which has hidden GST included in it. So now this part ki banks are running with the public's money, this concept does not hold good, at least for me. Maybe others, they may not agree with me. They may say, what I am talking about is not right, this is wrong, or this does not hold good. Things may happen like that. But now from this, now I will shift slightly from here to the courts once again. When we ask, when we go to court and we say, "Sir, please give some relief to us," they say, "No relief. The contractual rate of interest, which was fixed, that in rate of interest you will have to pay further till the date the repayment is made." Now, what is the interest? Interest is nothing but the income of the banks. Now, from this part, shifts slowly to a commercial enterprise, where when he sells some product, he has some profit hidden in it. That is his income. Huh? But when if he fails to get money from his buyer, and when he puts a money suit in the court and asks for the payment of it, does the court award the his income which he lost for not having received that money from his buyer? No, the court does not do that. Then why this income part should be given to the banks? Now, here, Miss, I'll discuss something very different, which most of us have not thought about it. When I just passed out, at that time, I enrolled myself with Central India Law Quarterly. This is a law quarterly which gets published from Jabalpur, if I'm not wrong, Jabalpur or Bilaspur. So I became the life member of it. Now for quite some time, I'm not getting the magazines from them. There they were citing the observations and the articles of the judges and the courts, and many things were given. I used to read those. So let us know about what I read at that time. There it was in one article I found they said the courts, when they award interest, they cannot award interest more than the rate of interest at the savings rate prevailing on date, that too calculated on simple interest basis, not even the compound interest basis. Whereas today the courts are awarding interest on the compound interest basis, not on the simple interest basis, till the date the amount is repaid. Now the question comes, when someone has defaulted, who went to take money from you, he definitely did not have money with him. Maybe he had ideas, he had some vision with he wanted to go with, and he somehow uh, missed his opportunities in his venture, and has landed into a loss making situation. The person who did not had that money to start that venture, if you are putting that person into the burden of further interest, penal interest, compounded every month, and then you are putting the bouncing charges for the checks or the ECS which you have taken from him, then how can you expect the person to repay that money to you? Now the question comes, then why this practice is being taken up? The point is, when these people ask for, go for borrowers, go for loan, and when the financial institutions they extend loan, they go for the guarantors or they go for the securities. They keep those in hypothecation with them. When you lose this, when you are unable to pay, they simply get those disposed of and get the much higher amount realized from them, where that is nothing but their loss in business on charged by way of penal interest, by way of interest. That is the income which they are taking on amount which was a very small amount earlier. So how we are going to overcome this? The idea is now here we'll have to go to the RBI formula. When someone defaults in payments, then account is initially taken to be a sticky account. When someone fails for the first 3 months, they call it the account is a sticky account. And when after further next 3 months, if still the person is not able to pay money, not able to repay to the bank, then the account is considered as a non-productive asset, that is a NPA account. Now when an account is declared as a NPA account, then bank is under obligation to charge to charge the interest in the separate account, and not burden the existing loan account with any further interest. Because the reason is, the Supreme Court has also held just to the key any interest plus principal becomes the principal for the next stage to be repaid. Now, not to burden these people with the when the bank claims for the principal, the bank again at least my principal amount or should get back. Then what about that interest amount? Then it will be seen ki what was the interest they are charging, and then on that other reliefs can be extended. Now, but they don't do that. They keep burdening the account, the defaulter's account, and you'll be surprised to know if there is a figure of 1 lakh, then it shoots up to more than 2 lakhs, 2.5 lakhs in just 1.5 years time. So how the person is going to repay it? This is nothing but a scheme to take away the properties of the people. That is why when they attach the property, even when they attach the properties, they don't follow the stipulated time in which they should go further and dispose of the properties and adjust the money. They delay it. They keep burdening the account. And when the properties are sold, ultimately the difference amount comes zero, and the borrower, he loses his property also. Where when government says ki we are giving you money for making houses, which shall be your lifetime achievement for getting a house for your family, there the banks are taking away the houses away. Now law says ki there in Central Law India quarterly, there was one more thing written. They said ki there should not be any order for taking away the tools of earning of any individual or of any enterprise. Otherwise, how the money will come back? But they don't think of that. Even those who are having small lathe shops, in that lathe shop, that lathe machine is his tool of earning. That is taken away. He's left on the street. Has he done a crime? He has not done a crime. But we, in our society, we are having a very wrong concept about the defaulters, and then now they have come up with the very fine words. The defaulter is an intentional defaulter. He is a deliberate defaulter. These words, these phrases are put in the complaints by the banks. He's an intentional defaulter, and so we are going ahead with this. He's a defaulter by habit, so he's going by this track. But now, when someone has taken money, maybe you come forward, you allure people, you take this money for your personal expenses. You can repay from your salary, and you can repay after some time when you break your securities, that your FDs or LICs, or those things are there, and the people they get convinced and they go for it. It is very surprising that life insurance policies are also taken into hypothecation by the banks. Those are also taken into hypothecation, and someone after that is left with nothing in his hands. Even those who are the salaried people, they also face this unending torture. In that Central Law India quarterly, it was written that if there is a debt which of a salaried person which he is to repay, then no one can take claim repayment for more than 2.5 years period of 2/3 of his salary. Beyond that, they will have to leave him free. But now, where is this? Now, here I will tell you, the Supreme Court, not now, but in 1952, they had observed that when the courts decide for making decide against the defaulters, they have to take care of what is his present status of repayment, and if his present status of repayment does not suit him, that is not permitting him to repay, then he should not be burdened with an order which is not be justified against him. These observations are also made by the Supreme Court, where what I'm talking about is not that our courts and our apex courts have never thought about it. They have very much thought about it, but we are ignorant about the courts. Now I'll tell you again, I'll come back to CIBIL. Again, I'm coming back to CIBIL after talking of courts and bringing the banks in between. Since our topic is interlinked, they will be coming in between in intermingled way. A gentleman, he defaulted he settled most of his credit card accounts and the personal loan accounts with the bank during that recession period, 2008 to 2010. The recession was there till 2011-12. He settled most of the credit card accounts, most of his personal loan accounts, and he was satisfied ki no, and I'm not going to take any further. And where he was not able to pay, he said ki no, for this I'm not, which went time, but he said sorry, I'm not able to pay anyway. But when that gentleman went for taking a education loan, he the loan for his child, the child was not given the education loan for the reason that the CIBIL score of the parents is CIBIL history of the parents is adverse. Then he said, ki, bhai, how you can say that? It is not my child who has defaulted. It is me who had settled the loan accounts. And in all honesty, I paid that money to you. And you gave me no objection certificates. They said, all those certificates given to you, fine. But the thing is, ki in our record sheet, these accounts were settled and balance amount was written off. So this written off remark is putting a adverse history against you, so your child will not get the education loan. He said, okay, let me find out. He went to the lawyers. He found out, is there any relief to this? He observed, yes, there were the orders passed by your courts in the south. They said, no, the adverse history of the parents will not affect the extension of loan to the child. They simply put that if I'm not wrong, then the Karnataka High Court and Madurai High Courts, they decided this not now, but in 1900, this 2015, 2017, they decided upon it. The gentleman went with those order copies. You see, the High Court of Karnataka and Madurai have observed this, and on the basis of that, those the banks, they on the order of on the basis of the order, this Karnataka, they have extended the education loan to the child. So now you can also extend the education loan to my child on the taking this reference of these orders. See, this is the principle. When any order is passed by a high court, unless until it is challenged or it is set aside by a higher bench, it is considered to be a rule. That is it comes as in the form of a law. This which every one of us know. But the banks, the legal chief manager legal of that bank, he said, no, we give a damn to the orders from the High Court. We give a damn to them. We will not extend this money. We will not give education loan. The parent was very much disappointed. He made a representation to the higher ups. He made representation even to the chief executive officer of that bank. He see, this is happening. This education should be given. Otherwise, the child will lose his educational career, which the education which he has already achieved. He has already covered now. But they also did not give a heed to this. So the question is, when these banks don't give heed to the law of the land and they want the everything earned and transferred into their pocket, then why stringent rules should not be framed against them? No, you will, under such circumstances, you will have to follow these. Even the representation before the government departments by that gentleman were not heard, and they were kept aside. As a result, in our West Bengal, this student credit card scheme, where this scheme was launched, most of the students, those who were studying in the cream institutes of the state, they did not get loan, and the scheme could not help them. because banks had a wonderful criteria for extending the loans to them. They said the institute has to be more than 3 years old. No, an institute which is 1 year or 2 years old, which has come up the university institute, they will, to the students of those, we will not extend any loan. And further, they have to come with the this employment record of that university or the institute key of the previous 3 years. Now, if some institute which has come up and has been able to get the students employed uh, on the last 2 years occasion only, and now the third year will come after that, but they said, no, sorry, we'll not extend. So they had one or the other point, and they started disqualifying the loan. So for the social scheme, a scheme for which the government came forward to get the society improved through education, even the educational scheme has been put into drains by the adverse policies or the criteria of the bank. Now, how to overcome it? People say, ki, when is there any remedy? No, I find ki there is the only remedy is ki when you get trapped into a case, there you have to go and face them. You have to submit to them. Whatever is there with you, you have to give to them. Now, only thing is we come across in the society, when we move out, we find people saying, ki, no, there is such organization, those will get your loan settled, then your CIBIL score will be improved. All those are humbug things. They are simply trying to make money. Unless until you are able to pay the full amount to the banks, no CIBIL score will get improved, and no any further loan or the credit facility shall be available to you. Then people say, Kinare, don't do this. Bank people, when these collectors they come, they say, you talk to your relatives, you talk to your friends, take money from them. And when you take money from them, and you, in the hope that after repaying this getting this account, I will get fresher, and from there I will be able to repay to my friends and relatives. That situation never arises, because that thing gets when getting settled makes you ineligible for further fresh loans. So don't borrow, don't beg, don't steal. If you are able to repay to the bank the amount which is actually due, then it is okay. Otherwise, settlements which are coming will not help you in future. Rather, with that money, try to start a new life once again, or request your friends, your relatives, your well wishers to support you in starting your life once again, and then come back on your footing. The banks, though, if bank people are hearing me, they will simply be matlab ki, must be boiling. They will, if they find me, they'll say, oh, he is matlab ki, provoking people not to pay money to us. No, it is not that. We are advisors in the society. We are officers in the court, and we will talk something logical which will have impact in a positive manner on our society, or on the decisions given by the court. We'll never try to mislead people. Let banks improve themselves. Let bank not stick to the civil criteria. Now, one more thing I'm going to tell you, ki, why we should not be given enough money from the bank if when we want to. We talk, every one of us talk about constitution, article 21, this right or that right, and so many things, right to live or right to live, right to earning, right to this, right to that. So now, right to your earning livelihood is also means making the facilities available for earning of your livelihood available to all, irrespective of your position. But that is not done. I have seen people, those who are living in big houses, they are now moving on the street. They go and stand in front of those small hotels where people are eating food, taking food in the afternoon, and they people stare from a distance, and they are not able to go and eat food there, because they have been ruined by the policies of the bank, by the decisions taken by the courts. I'm sorry to say, with all respect, these our judges are at one time ignorant about the society, and the bad effect of the decisions which go and ruin the society at large. Now this my submission is going to be endless, huh? Because I deal with such things, I have come across such people, I have been in working with them, and I find the things are very difficult and very different for us to. So I think I should give a break here, because after listening for so much of time, you must be thinking about taking water and something. Anyway, you may please take. And if you want anything to know from me, you may ask. But let us not go sticky to sections. Let us not go sticky to acts. Let us discuss in different perspective, so that our this discussion comes out very very meaningful and effective for all of us, and let us learn something out of it. And when we go to practice in the courts, let us, one thing is what is I would like to, but like it
Sir, sorry for interruption. Anurag sir.
we should always be political with the law. I think if that is done, then everything will be fine.
Okay,
So, hello
thank
friends.
you. Yes, sir. Thank you so much for such a insightful session. There are few questions I would like to ask you with you, sir, with your due permission.
You may please.
Yeah. Further, I will be continuing the session. Vedant will not be doing so, as due to some technical error on his part, he is not available. So I will be continuing the session. Okay, sir. The questions are as follows. Firstly, there have been several cases of defaulters absconding to other countries. What can be the role of the courts of law to prevent such things from happening?
No, those who are absconding, they are the intentions are known to us, and for that we have the provisions in our law. We attach their properties, we put them on sale, we try to recover the money out of those properties. First, that part is to be carried. What we do, we first run after them. We first try to find them out and try to bring them back. If someone, when he has run away, as we do in our criminal cases, when someone is absconding, then we put notices on his premises. Then that premises is taken and attached, and then it is finally sold off. That process should be adopted, not simply chasing them up. Once this part is taken over, care is taken over, your liabilities are reduced, your requirements are reduced, then after all, definitely they will come back. But those who are having this running away tendency, they are definitely the intentional defaulters. Yes, for them this term intentional defaulters or deliberate defaulters is appropriate, but not for the general society members.
Okay, sir. Moving on to further question. Before proceeding, sir, I would like to tell that I think your camera is tilted. If you can check it just once. First.
So, see,
it's yes, it's fine right now. It's fine.
Is it? Are you able to see?
Yes, sir.
So should I click it once again?
No, sir. It's completely fine right now.
Okay.
Okay. Sorry for the disturbance. Moving on to further question. How do you think that sudden increase in use of credit cards and BNPL services, that is buy now, pay later services, will affect our economy?
This will help banks. This will help banks and the big business houses, those who are selling items at a higher price than the normal price. The big malls, because these cards basically higher purchase option offers, and these cards are basically used in the malls, not in the small shops. They don't entertain those in the malls, and their business will improve. definitely, and the tax collection will go up. But with the present state of economy in the country, I think the borrowers will be affected in long term. Now I'll tell you how. I'll just out of this. Now, we are very much aware of this housing loans. Okay, Achha. And normally a period of 15 to 20 or 25 years is taken. Now I'll cite a very small example. If you buy a house of 25 lakhs today for a period of 20 years or 25 years repayment, and if you calculate the interest payable on that, you will find at the end of 25th year, say for our discussion sake, at the end of 25th year, you have paid almost 24.5 lakhs as interest to the banks. And the price of that flat is now 50 lakhs. So you have paid 50 lakhs for a house over a period of 25 years. And now when you divide now I'll go to the another analytical part of it. If you have taken a flat in a building which is having 10 floors, and every floor is having say 4 flats, five flats on every floor of 1,000 square feet each on 10 floors. So it comes to 5 into 10, 50,000 square feet. Now, when you go for this purchasing houses, practically that is for a period of 99 years, if I am not wrong. And after that, they say the life of the building will, and now supposing this building is demolished after 99 years, and now your claim for share in the land is coming. Okay, so now divide how many people you are. 5 into 10, 50 tenants, 50 occupiers. What is the land area of that building? Is 5,000 square feet plus extra space which has been left around, maybe 6,000. Now divide the 6,000 by 50, how much it comes? Maybe 120 square feet. Maybe 120 square feet per occupier will come. The space for which you have paid almost 50 lakhs of rupees. So if we consider this hire purchase through these cards, paying in the installments spread over 24 months or 18 months or 12 months, more or less this concept plays there. You are paying a very high price. That is why people fail. Next, please.
Sir, yeah, moving on to another question. So, whether updation of CIBIL score is borrower's statutory right?
See, this is their internal. This is the internal. You have the right to claim ki when you have paid, you update my CIBIL score. Okay, when I have repaid, you update my CIBIL score. But they at times the remarks which they give, those are the remarks given in the traditional way, on which you don't have any control. But you can definitely, if this issue is raised and taken up on the welfare basis of the borrowers, and if a court comes up with a decision on it, then it will come as a right. Otherwise, it is their internal thing. We may claim that you have not updated, you are supposed to update. Definitely a right comes in, but then we fail on it. It is not very effective.
Okay, sir. Moving on to another question. This will be the last question because there are more than 20 questions. I think it will be too lengthy to ask all of them. So I think we can go with the last question with your permission, sir.
Please.
Yeah. So the last question is whether credit rating agencies are legally bound to consider objections against the rating given to a debtor.
As a matter of fact, this credit rating which they are supposed to give to the debtors, that is, they are under obligation to do that. They are under obligation to do that because the act under which they are incorporated, they have those provisions.
Okay, sir. So, sir, I would like to proceed with the vote of thanks. So I, on the behalf of whole Just Corpus team, would like to thank you, Advocate Anurag Chaturvedi, sir, for giving your precious time to us and sharing such a knowledgeable session and for such an insightful session. Thank you so much, sir.
My personal thanks to all of you for being with me during this time and sharing my thoughts and and I matlab ki welcome you all for another session also if you ever want with me. Thank you very much.
Yes, yes. Secondly, I would like to thank my friend and colleague, Mr. Anurag Chaturvedi, for conducting and helping out me in conducting this session, for inviting, sir. So thank you so much to both of you. Thank you so much, sir. Hope to host you